let's review some of the key components for your test about the Constitution. In the Constitution, there are 6 principles of government that you must understand. We talked about this first one originally. This is the concept of limited government. In this, anytime you see it, you need to think to yourself, we are limited based on the Constitution. So government can only do what the people allow it to do, meaning that whatever is in Article 1, 2, and 3, that is the description of the national government. It describes different powers known as expressed powers, implied powers, and inherent powers. And we'll talk about those in Chapter 3. But we are the government. Do you remember the two sides? Was it anti-federalist or federalist who said they wanted a written list of protections? If you said anti-federalist, that is correct. The Federalists basically went on the argument, we can only do what the Constitution says we can do. But people did not trust good people to always be in place, and they wanted that. So they wrote these 9 amendments. The first 9 amendments describe the limits placed on government. If you look in your book, the wording of the First Amendment, Congress shall not abridge the freedom of speech, press, petition, assembly, and religion. This is known as the rule of law. Limited government and the rule of law mean the same thing. Anytime you see those, it's just the simple concept that government is not all powerful and is under the power of the people. Which brings us to our second point, popular sovereignty. I went over this in class several times. Anytime you see this word, it means the people decide, the people rule. The people are the source of government authority, but it rests in the Constitution. The big deal about this is the people wrote the Constitution. We make it the ultimate source of government. And when we elect officials, we are loaning power to people based on the power of the Constitution. So this is our legitimate source of governing authority in the world, but the people are the base of it. That's the concept of popular sovereignty. The next principle and the fourth one, separation of powers and checks and balances, are huge ideas to prevent tyranny. The discussion was, we have had so many despotic leaders or despots in power, authoritarian, tyrannical, that over time they said, why are we giving all sources of power to one group? So there was a man called Montesquieu, and he said, really, why don't we divide power into different bodies? He wrote this book called The Spirit of the Laws. Anytime you see Spirit of the Laws, you must think of Montesquieu. Montesquieu was the original person in 1748 to really put those political ideas down on paper. It came before the Declaration of Independence. It came before the writing of the Constitution. It came before ratification of the Constitution. It was this idea that James Madison took that said, really, let's separate. So it's going to be different than a pure democracy. We are going to separate power, and that's what's going to make a republic work. If you recall, number 51, Federalist 51 said, we are going to have a government different than Athens or Sparta. We are going to separate power into different entities. The bottom line, no one branch would have enough power to dominate the other. So what they tried to do was give a portion of power to one, but there's always a check on the other one. I've put Article 1, 2, and 3 as an example of how powers are given to each branch. When we read Article 1, Section 8, it lists all the powers of Congress. When we look at Article 2 and Article 3, it clearly delineates what power is given to each branch. But let's also look how the Founding Fathers took this other principle, and this is one of the most unique things about our government, is this whole idea of checks and balances. They're independent, but they have power over another. So let me give you several examples. The one I've given you right here is the basic power that the President appoints federal judges, but the Senate confirms. So the legislature, two branches are always involved. This is the executive branch. The president appoints and the Senate confirms. This is a picture of Sotomayor. She's the most recent appointee along with Kagan to the United States Supreme Court. This is Chief Justice Roberts, and he is swearing in Sotomayor. That's her mom. Another example, Bush nominated Roberts, and he also nominated Justice Alito to the bench. So these are faces that you will see, and that is a perfect example of checks and balances. If you look in your book, if you have your book, you might want to pause and get that out just for a second. This is a key chart, and this is one of those cornerstones that you need to understand. So let's look at how does the legislative branch check the executive. Well, Congress approves nominations, and those would be cabinet nominations, federal judges, and they also control the budget. One of the big trump cards of the legislature is that they control the power of the purse. All money has to be appropriated through Congress. And so if the president has an idea, it still has to be carried out through the budget, and this is where they can hold an idea over the president. It can pass laws over the president's veto. Remember, if Congress approves a law by a simple majority, it can go to the president, who can veto the law, and then it goes back to the House and Senate, and they can override a veto, but it's a larger percent, it's 2/3. So this 2/3 check is very difficult to achieve. So even the threat of a veto can send Congress to a compromise rather than to just do away with it. Another huge check is that Congress can impeach the president or can impeach a federal judge. Impeachment is done by the House voting on the charges, and the Senate actually carrying out the trial. We have only had two presidents impeached. Andrew Johnson was one that was impeached, and Bill Clinton was our other one that was impeached. The one person you probably thought, Richard Nixon, he was not impeached. The House of Representatives was drawing up articles of impeachment, and he decided to resign, and then President Ford pardoned him from any further punishment. So those are just some names you might recognize. How does the executive check the legislature? Well, the president can veto congressional legislature. That's probably one of the largest things. And they also have a bureaucracy which, when they make a law, the president carries out the law. And so sometimes the executive branch has a huge range of interpretation powers to carry that out. So let's look at the judicial branch. Congress controls the judicial branch through confirmation hearings, through presidential nominations. A very contentious confirmation hearing was when Clarence Thomas was nominated to the United States Supreme Court. He barely passed that nomination. But another person, Robert Bork, and we'll talk about this with the Supreme Court, but Bork was a person, and he was not approved during the Senate confirmation. So sometimes presidential nominations are not a guarantee. They go through very, very thorough Senate confirmation hearings. Congress can impeach judges and also remove them from office. Now, what the judicial branch can do is they can declare things unconstitutional. The very first time an act of Congress was ever declared unconstitutional was in the landmark court case called Marbury versus Madison. And when they declared something unconstitutional for the very first time, it was called the power of judicial review, and I'll mention that more in just a second. Another thing the judicial branch can do, the court can declare presidential acts. So these are called executive acts. So if the president does something unilaterally, it is called an executive act, and sometimes those can be brought before the court and declared unconstitutional. So that is a perfect example of checks and balances where two branches are involved in checking the power of the other, so there is balance in government. Now, the very last two are called judicial review and federalism. I just mentioned Marbury v. Madison, but here's the key to this. The word judicial review in the judicial branch is not mentioned in the Constitution, but it occurs anytime they interpret an act of Congress. The very first time, again, Marbury v. Madison, this was a landmark case where Marbury and Madison, and I'll get into this in the next couple slides, but they saw something that Congress had done, and they said it's really overstepping the bounds of what Congress can do. So the Supreme Court Chief Justice at the time was John Marshall, and Marshall said, you do not have the power to do that, and so they went ahead and canceled that act of Congress. So anytime you see the words Marbury v. Madison, definitely think judicial review. The last several that I want to go over with you, this is the concept of federalism. And what this means is that there are two sources of governing authority, a national or central government and state governments. It was a compromise between the Articles of Confederation and a too strict national government. They compromised over and over again. You can see through the Constitution that concept of compromise. This also is embodied, that 10th Amendment. Anytime you see the 10th Amendment, think to yourself, federalism. This is embodied, that any power not given to the federal government is reserved to the states. The concept of reserved powers can definitely be seen right here. So I want you to look at this term. Anytime you see reserved, the definition of is powers are given to the states through the 10th Amendment. So state powers, such as the power to license, the power to grant certificates for different jobs. Those are all state powers. The power to give a marriage license, a driver's license. Those things are not mentioned in the Constitution, so it's given to the states. The last several things that you can look at, this is Marbury v. Madison in a little more detail, but it's also discussed in your book, and I will go over this more next time. There's a little video that you can watch, but that Section 13 of the Judiciary Act of 1789 is the part that was unconstitutional. And basically what's going to happen at the end is that the Supreme Court will rule that it's unconstitutional, and Congress was shocked that they had done something that stretched the bounds and that the judicial branch called them on it. And so the power of the very weak third branch was actually increased with this decision. But it's the very first one. It's so landmark. I can't tell you enough how that really changed the whole course of the balance of power between the three branches. So I hope you understand these 6 constitutional principles embedded in the Constitution. Going back again, limited government, popular sovereignty, separation of powers, checks and balances, judicial review, and federalism. You will see these concepts over and over and over again throughout the year.